Good evening, everyone, and welcome to AJ 101 Criminal Law Online. My name is Tony Farrar, and I am your instructor for this semester. Since we have already covered the syllabus review, let's go ahead and jump right into Chapter 1, which is going to cover the nature and history of criminal law. Now, before I get into this a little bit further, a couple of quick housekeeping items that will definitely help you be successful in this course. The first item is to make sure that you have the textbook. There is only enough time for me to spend about 45 minutes or so covering each chapter. Therefore, having that textbook and reading those chapters will allow you to add additional context to a lot of the different terms or definitions or case laws or other things that we will be studying as we go through these lectures. Now, also, at the end of each chapter, you will find a list of key terms, which are very important for you to know, and also a section titled Summary. And this is just kind of a summary of the chapter that hits some of the high points. So please take the time to look at the key terms and to also go over the chapter summary. Now, lastly, in your Canvas shell, in each weekly module, I do have the key terms on a separate page there for you to kind of give you a little bit of help. Along with that, I have the corresponding page numbers for each one of those key terms as well. So with that being said, let's jump right into Chapter 1 with a quick introduction. Now, in June of 2000, Lorico Garrett, 22, of Manchester, Connecticut, was arrested for car theft after he pulled the stolen vehicle he was driving into a convenience store parking lot to ask a police officer for directions to a nearby street. Now, although he answered the man's questions, Officer Robert Johnson found that 2 a.m. encounter was a little bit suspicious, and therefore he ran a radio check of the vehicle's license plate of the Cadillac that Garrett was driving. When dispatchers reported the vehicle stolen, Johnson summoned additional help and drove to the street where Garrett was headed. Garrett was arrested and charged under Connecticut law with the taking of a vehicle without the owner's permission, which is a misdemeanor punishable by less than 1 year in jail. And very quickly, just understand that as we go through a lot of these different cases, please keep in mind that we're not specifically focusing on California law. We'll have some examples from different states across the United States, and every once in a while I will interject some things closer to home like California. So, what is criminal law? Well, although most people would agree that it's not very smart for that car thief to stop and ask directions from a police officer, it's not a crime to be stupid, if you will. Car theft, of course, is another matter, and we'll talk about some different terms and definitions in other chapters. However, just understand that not all rules are laws, and fewer still are criminal laws, and not all have binding legal force. Now, sociologists, for example, distinguish between norms and mores, while philosophers and others talk of morals and morality. And we'll go through a couple of those as we go on through the chapter. So let's start off with, again, what is criminal law? Law is defined as that which is laid down, ordained, or established. Basically, a body of rules of action or conduct prescribed by controlling authority and having a binding legal force. And again, not all rules are laws, and not all rules have this binding legal force. And I mentioned just a minute ago a couple of definitions for you to know. Morals, these are considered ethical principles. And norms, these are rules that underlie and are inherent in the fabric of society. And when social norms are unintentionally violated, a request to be excused is generally accepted, because remember, we're talking about social norms. Mores, on the other hand, are rules that govern serious violations of the social code. So when you look at this diagram that I have in front of you, looking about what is criminal law, we can start at the top and we can look at the different types of offenses. Well, we have criminal acts, and then we have what we call maybe taboo acts, and this is defiant behavior, violation of mores, if you will. And then at the bottom, the violation of norms, what we might consider uncivilized behavior or immoral behavior. So again, crime, deviance, and norm violation, although there are many ways rules can be violated, only a select few offenses are actually what we would call criminal acts. Now, only human conduct that violates the criminal law can be called criminal. The distinguishing characteristic here between a crime and other deviance is the presence of a public prohibition. Okay, in this case, it might be a law. Okay, and the authority of the government to enforce that prohibition. So an example that I have here would be, let's say, the California Penal Code. And inside of the California Penal Code are several different sections. As a matter of fact, thousands of different codes and sections that basically spell out, or define laws along with a corresponding punishment. So hopefully that kind of makes sense to you. So again, criminal law, by definition, the body of rules and regulations that defines and specifies punishments for offenses of a public nature or for wrongs committed against the state or society. And sometimes you might hear the phrase penal law instead of criminal law. And criminal law defines basically what conduct is criminal, and violations of the criminal law are referred to as crimes. And so just backing up really quick, understand that, when we talk about, norms and mores and morals, especially morals, those being those ethical principles meant to guide human conduct and behavior, or standards of right and wrong, everybody has a different level, if you will, of what they believe might be right or wrong. And that's one of the reasons for laws, is to kind of have some type of level playing field where people can understand or know by definition or by law what might be right or what might be wrong in certain circumstances. So an example, when we talk about criminal law, let's look at burglary. Every person who enters any house, and there's a long list of locations that go along with that, or whether it's a house, a boat, a car if it's locked, etc., with the intent to commit grand or petite or petty larceny or any felony, is guilty of burglary. So this is an example of what might be spelled out in the penal code, and the definitions are quite a bit more thorough, but I'm just giving you an example that you can take a good look at. And it'll also spell out the punishment. So it'll, here, staying with burglary, burglary is punishable as follows. Under subsection A, burglary in the first degree by imprisonment in the state prison for 2, 4, or 6 years. Burglary in the second degree by imprisonment in the county jail not exceeding 1 year, or imprisonment pursuant to subdivisions H of section 1170. We won't go into all that. I just wanted to show you that, again, every code section will have the definition of the code, the example here, burglary, and also the punishment. And both of those need to be present for something to actually be a law. So laws in the United States have been shaped by a number of historical developments and philosophical perspectives, if you will, and criminal law in particular has been greatly influenced by natural law theories. And the rules of conduct, when we talk about natural law, the rules of conduct inherent in human nature and in the natural order, which are thought to be knowable through intuition, inspiration, and the exercise of reason, without the need to refer to man-made laws. And these natural laws date all the way back to Aristotle. Again, a lot of our perspectives when it comes to criminal law, or the philosophical perspectives as well, have been greatly influenced by history. And here, under natural law, we basically, the theory believes that individuals naturally possess certain freedoms that may not be encroached upon, if you will, by other individuals or governments. And so that's the natural law. So the rules of conduct, again, inherent in human nature and in the general order, which are thought to be knowable through intuition, inspiration, and the exercise of reason without the need to refer to man-made laws. And then we have positive law, the law that is legitimately created and enforced by governments. Now, some believe that positive laws should be bounded by the natural rights of individuals, and many also believe that for positive law to be legitimate, it must be created and implemented in ways that are acceptable to most people. And if you know how laws are created, let's say in the United States, they're generated by individuals, but they're brought up through the legislature, if you will, and different laws can be brought about based on the need, and also, and people will vote on these. So again, this part about acceptable to the people, it is something that has to be acceptable. Now, an example could be the legalization of recreational marijuana. For the longest time in California, this was something that was not on the radar until recently, when marijuana was in fact legalized for recreational use. And basically because, again, this was acceptable socially to the majority of individuals, and therefore this was placed on the ballot and people voted for it, and it was put into effect. Now, ancient laws, this is the development of criminal codes and how they can be tracked back several thousand years. And we can learn from ancient codes that have some legal principles. They have held significance for people for a long time. And a couple of examples I have would be the Code of Ur-Nammu. This is the oldest known law code surviving today. And it is from Mesopotamia and is written on tablets in the Sumerian language from 2100 through 2050 BC. And imagine, when you think about it, how that we actually had laws that spelled certain things out, or codes from that long ago. Another interesting one would be the Code of Hammurabi. And this is a well-known preserved Babylonian code of law of ancient Mesopotamia, dating back to about 1754 BC. And it's one of the oldest deciphered writings of significant length in the world. And while it's hard to see the photo, I do have a couple of links in this lecture that you can go to, time permitting for you, that you can look at, and it'll go into a little bit more detail on the Code of Hammurabi. But it is pretty impressive that we have some deciphered laws dating back that far. So that moves us into something called common law. And before the Norman conquest of 1066, most law in England was local. It was created by lords and applied within their particular realms. and accordingly law was decentralized and varying. And when William the Conqueror invaded England in 1066, he declared Saxon law absolute and announced that he was the guardian of the laws of Edward, his English predecessor. Now, William, however, in seeking to add uniformity to the law, planted legal seeds that would grow and eventually merge into one common law. And this is kind of where the phrase comes from. And he established courts that would have some hierarchy and have national jurisdiction. And the decisions of the highest court, the King's Court, were binding all across England. And over time, these courts developed their own processes and rules. And one such rule we're going to talk about in a moment is this doctrine of what they call stare decisis. Now, more by definition, common law is a law that originated from the use and custom rather than from written statutes. In California, in order to be a law, there needs to be something written. It's statutory. But this is common law. So again, this is something that was more customs. And again, this refers to non-statutory customs, traditions, and precedents that help guide judicial decision-making. And it involved the transformation of community rules into a national legal system. And as previously said, the controlling element was precedent. And out of this began the development of what we know today as stare decisis, which basically means let the decision stand. And this phrase, if you will, or this concept embodies the idea that cases with similar facts should have the same law applied. And the earlier case is commonly known as what we call a precedent case. Now today, this principle establishes that a previous legal case is either binding or persuasive for a court when deciding subsequent cases with similar issues or facts. So you can see it's, how history plays a role in a lot of the current things relating to law today. So by the 1800s, common law was giving way to the authority of courts to declare the law and to written civil and penal codes in America. And common law continues to be important for many reasons, even though it's primarily being replaced with court-created criminal laws. Most law now is what we call codified or written, if you will, but still acknowledges the common law roots of contemporary penal legislation. And when you talk about common law in criminal law, California typically doesn't recognize common law, but there are, I believe, a few states that still do. Now, occasionally, individuals may be arrested and tried under common law when appropriate statutory provisions are not in place. All states today except Louisiana remain common law states. Louisiana uses kind of a modified civil law system because it was once a territory of France. And both common law and judges continue to play a significant role in the development of law. Statutes are often broadly drafted, making interpretation and gap filling necessary. So we can always look back to common law and what has been precedent in order to fill some of those gaps. Common law today, well, statutes are, again, often codifications of common law. So they may have started as common law, but now they've progressed into something to where they're codified or they're written. And today, all common law nations have legislative bodies that are the primary lawmakers. So if you look at a few here, England has Parliament, and the United States has Congress, and the states have legislatures, and a lot of time it's these legislators are the ones that are pushing through or bringing about change with some of the new laws based on public need or what have you. So as we finish up with the common law piece, here's a little diagram that kind of shows you how things have progressed. And while we've already covered it, you can take a look at how, again, the common law has changed throughout history. So what's the difference then between, let's say, civil law and common law or criminal law? So let's talk about how we distinguish civil law. Well, at this point, criminal law should be distinguished from civil law in our discussion. And whereas criminal law concerns the government's decision to prohibit and punish conduct, because that's what laws do, civil law governs relationships between parties. And civil codes are those that regulate private relationships of all sorts, including things like marriages or divorces or an inheritance, adoption, and many other forms of personal and business relationships. Civil actions come in many varieties, and typically some, just to give you an example of some, would be a breach of contract, where two people agree and sign a contract, let's say for work or services rendered. Could be a domestic situation, whether it's a restraining order or a divorce or something similar. And then we need to kind of throw in tort, which is the unlawful violation of a private legal right other than a mere breach of contract, or the violation of a public duty that accrues special damage to the individual as a result. And there are three forms of torts to kind of go over really quick. The first one, negligence, and basically they call it a tortfeasor. So when a tortfeasor, a recognized entity, a business or a person, okay, injures another through unintentional but careless behavior. The next one is an intentional behavior that harms another. Many crimes can also be intentional torts, like assault, battery, and destruction of property. And then the last one is what we call strict liability. This is basically where defendants are liable if they are the cause of harm, even if they are not negligent because they engaged in, let's say, extremely hazardous type activities. So torts may give rise to civil liability, where the injured party may sue the person or the entity, business, let's say, that caused the injury, and ask the offending party to be ordered to pay damages. And parties in a civil suit are typically referred to as the plaintiff or the defendant, and most civil suits are brought about by individual people. Now, an interesting but quick case study here, we look at the case of O.J. Simpson. Now, O.J. Simpson was found not guilty of murdering Nicole Brown Simpson and Ronald Goldman as judged by a criminal court jury, yet a civil court jury found him legally responsible for their deaths. So the question I want you to think about for a couple of minutes, or I'll come back to, is how is the civil court's determination different from criminal? How can that happen? And is OJ still not guilty of murder, even though he was found legally responsible for their death? So just kind of chew on that for a few minutes, and I'll either come back to it or we'll hit it at the end of the lecture. But these are interesting things for you to think about that should kind of make you think, hey, are these two different types of situations, criminal court and civil court? And the short answer is yes. Now, staying with civil law and being able to distinguish it, civil law is concerned with compensating injuries, more concerned with compensating injuries than it is with punishment. And along with that comes something called punitive damages. And these are monies beyond compensation. They are basically intended to punish or deter someone or some business, if you will, to continue to do things that they've done in the past. Some big examples could be the Exxon Valdez case. So in 1989, this oil tanker struck ground in Alaska waters, and the injury to the ship resulted in hundreds of thousands of barrels of oil spilling into the ocean, the largest spill by a tanker in U.S. history and the second largest spill of any kind next to the Deepwater Horizons spill of 2010. Now, subsequently, a jury awarded plaintiffs $5 billion in punitive damages. That award was reduced on a couple of occasions by appellate courts, and the Supreme Court later reduced the amount equal to the actual damages awarded by the jury, which was about $500 million, because the spill was caused by negligence. Punitive damages may exceed the 1-to-1 ratio in cases of intentional tort. So just so you kind of get an idea of punitive damages. Now, perhaps again, the most famous example of that would be the O.J. Simpson case, the 1995 wrongful death suit filed by O.J. Simpson, or filed against O.J. Simpson by the family of murder victim Ronald Goldman, and the suit demanded monetary damages for what the plaintiffs claimed was Simpson's role in the wrongful death of Ronald Goldman, and it alleged that Simpson and possibly another unknown defendant caused Ronald's death. In 1997, Simpson was ordered to pay $33.5 million to the family of Ronald Goldman and to Nicole Smith's estate after a California civil jury found that he was in fact responsible for their deaths. So again, kind of an interesting thing, but it shows you the separation between the two different types of courts. So with that being said now, and we kind of understand a little bit about that, let's look at types of crimes. Now, there are many different ways to classify crimes, but typically crimes are distinguished by their level of seriousness. This is one way to kind of think about it. And similar in a lot of states, the highest level would be a felony. The next level beneath that would be a misdemeanor. And then finally, the bottom level would be an infraction. Now, felonies, again, serious crimes, punishable by at least a year in prison, and you could get fines and other things levied against you as well. These would be crimes like murder or rape or robbery or kidnapping. So those are felonies. Now, misdemeanors, these are less serious offenses, generally thought of as punishable by less than a year of incarceration, typically in what we would call a county jail, so a lower level versus like a prison. And then the lowest level that some of us, unfortunately, have had the pleasure of receiving would be something called an infraction. And this is a citable or a ticketable offense, such as minor crimes that usually result in the issuance of citations, which can sometimes be paid through the mail. The easiest one that I can think of as an example would be, let's say, a speeding ticket. Technically, it is an offense. A criminal offense is just an infraction, but it is something that is where you can be issued a citation. So those are the different types of crimes, if you will. And along with that, crimes can also be classified as either what we call mala in se or mala prohibita. So these are a couple of different definitions again. Now, Mala and se crimes are those that are regarded by tradition and convention wrong in themselves. Such acts are basically said to be evil and immoral and are sometimes called acts against the conscience. And mala and se crimes include things like murder, rape, and other serious offenses. And they're almost universally condemned and probably would be so even if there were no basically laws against their behaviors. If they weren't specified in criminal law, those types of crimes would still be ones that people would basically understand that they're wrong in themselves. Now, on the other hand, would be something that we call mala prohibita crimes, and these are considered wrongs only because there was a law against them. So without a statute specifically prescribing them, mala prohibita offenses might not be regarded as wrong by a large number of people. And these crimes or these offenses often include the category of what the book will say are victimless crimes, and we'll have that big debate later on, such as prostitution, drug use, and gambling, in which a clear-cut victim is difficult to identify and whose commission rarely leads to complaints from parties directly involved in the offense. So an example would be if somebody solicits prostitution and they complete that act, yes, it's a violation, but the person, neither one of those two parties involved, whether it's the prostitute or the person soliciting the prostitution, they're not going to complain about that particular thing, that there's some type of violation, because they are both parties are involved in the offense. So hopefully that kind of clears that up. So these are acts, again, that are considered wrongs only because there is a law against that. And as I said early on, remember, everybody has a different maybe idea on what might be morally wrong, or those types of things that maybe are laws right now that shouldn't be. So how do we classify crimes now that we kind of have the definition, or we know what crimes are? Well, there are many other distinctions that can be drawn between types of crimes, but we definitely need to talk about the traditional classifications of offenses and what have you. And there are basically 4 types, and it's going to kind of go from state to state. It might be different again in Texas versus Florida versus California, but basically we're going to lump these offenses into 4 different types. And the first type is going to be property crimes. And that would be things like burglary, larceny or theft, arson, criminal mischief, vandalism, property damage, motor vehicle theft, fraud, passing a bad check, etc. Personal crimes. These are things against an individual. So it could be criminal homicide, kidnapping, false imprisonment, and some rape or assault sections. Public order offenses like fighting, public intoxication, or similar. And then finally, moral offenses, which would be things that would be lewdness or indecency or similar type offenses. Could even be things like pornography or prostitution, etc. So with all of that said now, and we've gone through a lot of definitions, and I apologize for how fast I've gone through them, let's look at the purpose quickly on criminal law. Now, Max Weber said that the primary purpose of law is to regulate the flow of human interaction. And without some sort of laws, modern society could probably not exist, and the social organization world would be unable to rise above the level found in primitive societies where mores and norms were primarily regulatory forces. I included an interesting link in here that will take you to a video that will it tells the story of basically a Western society's blackout, where the power grid goes out and people have to fend for themselves for quite some time. I believe the title is American Blackout. And it's interesting to see how things kind of take place and how things are just going, normal, if you will. And when this happens, crime starts to run rampant and people start doing all kinds of different things. So if you have a chance, you can watch that. It's not mandatory, but I thought I would kind of throw that out for you as well. Now, as is true of law generally, the criminal law has a process, like I say. Some say the primary purpose of criminal law is to make society safe for its members and to punish and rehabilitate those who commit offenses. And others contend that the basic purpose of criminal law is to declare public disapproval of an offender's conduct by means of public trial and conviction, and to punish the offender by imposing a penal sanction, if you will. Now, the criminal law also serves to restrain those whom society considers dangerous, often through imprisonment, home confinement, or other means. It also deters potential offenders through examples of punishment applied to those found guilty of crimes, and protects honest and innocent citizens by removing society's most threatening members. So in short, criminal law protects law-abiding individuals while maintaining social order through the conviction and sentencing of criminals. So here are just a few purposes of criminal law. So protect members of society from harm, preserve and maintain order, support fundamental social values, distinguish criminal from civil wrongs, because we know there's a difference, express condemnation of criminal behavior, stipulate the degree that should be of seriousness of criminal conduct, establish criteria for the determination of guilt or innocence, punish those who commit crimes, rehabilitate those offenders, and then compensate victims of crime. So all of these are just a few of the purposes, if you will, of criminal law. So now that we know some purposes, where are the sources? Where do they come from? Well, today's laws can be found in a number of sources, each of which I'll briefly discuss in this particular lecture. And these are living sources. And these living sources of the law can be distinguished from historical underpinnings of the law, such as ancient codes. So the first one is going to be constitutions. Now, the highest form of law in the United States is the Constitution of the United States. And the Constitution, however, is not a source of specific laws or criminal prohibitions, although it does define treason as a crime in there. Instead, it serves as a constraint on police and government power. And the Constitution basically sets limits on the nature and extent of criminal law that the government can enact. So it basically guards personal liberties by restricting undue government interference in the lives of individuals and by implicitly ensuring personal privacy. Now, we haven't gone over this, but I would highly suggest that you read, look up, or understand the Bill of Rights, which is the first 10 amendments to the U.S. Constitution, which were made part of the Constitution back in 1791. And just to go a little bit further, the U.S. Supreme Court, which basically does serve as our nation's constitutional interpreter, meaning that a lot of these cases that happen will go up to the U.S. Supreme Court, and if they decide to take the case, they will interpret the particular circumstances surrounding the case. And so the U.S. Supreme Court, again, serves as our nation's constitutional interpreter. So a constitution can be seen as the sole pieces of legislation by which all other laws and legislation are judge acceptable or unacceptable. And the constitutional provisions determine the nature of criminal law by setting limits on just what can be criminalized or made legal. So criminalized, just by definition, is something that is done to make criminal, to declare an act or omission to be criminal or in violation of law, making it so. So constitutional laws also, or constitutional requirements, hold that criminal laws can only be enacted where there is a compelling public need to regulate conduct. So, keep that in mind as we continue to talk also. Now, states also have their own constitutions. They cannot reduce the rights found in the U.S. Constitution, but some expand on them. And statutes, ordinances, and regulations, the U.S. Congress and the state legislature have authority to define crimes. And statutes, again, are the laws of the legislature. Now, in your book in chapter 1 on page 16, and I'm not going to go through the whole thing, it lists a number of requirements, basically, and restrictions as it relates to the Constitution. So the Constitution imposes a number of specific requirements and restrictions on both the state and federal governments. And it protects, as we've talked about, individual rights in the area of criminal law. And most of the restrictions, requirements, protections, and rights inherent in the Constitution as they relate to criminal law are in that list that I just talked about on page 16. So we're not going to go through them all. But you do need to understand that, again, states can basically make up their own laws as long as it's not conflicting with a federal law. So I just kind of talked about this right here. Now, one example of this, of states making their own law, actually two examples could be, for California, could be Prop 64, which was the legalization of the recreational use of marijuana in California. Prop 47, which was the reducing of some crimes that were typically felonies, and some of those were narcotic offenses, down to misdemeanors. And Prop 57, which deals with prisoner release and length of sentences and the feasibility and availability of those that were convicted, let's say, of property crimes or what have you, to be able to get out early. And all of these are things that have come about in the last several years that were not laws before, but now they are. So these are, again, through the legislature. So when we talk about sources of criminal law, one of the frameworks out there is what we call the Model Penal Code. And this isn't a law, but it's a proposed model which states can basically use in developing or revising their statutory codes. And it's undergone many revisions, but it does serve today as a suggested model for the creation and revision of laws. So if you decided in your state that you wanted to change or make a new law or something like that, or revise something, you could look to the Model Penal Code kind of as a foundation. So the Model Penal Code basically, again, serves today as a suggested model for the creation and revision of of state criminal laws, and it's divided into 4 different parts. And there's general provisions, there's definitions of specific crimes, there's treatment and correction, and organization and correction. And again, it's not a law, but it's just a model. And no state has adopted the model penal code in its entirety, but it's taken different sections or parts of it which have been incorporated into the penal codes of nearly all states. So again, it's just a good starting point and a foundation. A couple of terms that we probably need to understand. One of them, when we're talking about the modern U.S. legal system, is something called federalism. And this refers to a system of government that has both local and national elements. And under federalism, a central government coexists with various state and local governments, and each governing body has control over activities that occur within its legal sphere of influence. And in the United States, the federal government and the government of the states are, again, they're co-sovereign. Therefore, states have the power to make laws regulating or criminalizing activity within their boundaries. And an example of that could be possessing a firearm. There are some states that allow what we call open carry, and with a permit or etc., you can carry a firearm in a public place. And there are states that don't allow that. So the states have the power to make laws regulating or criminalizing activity within their specific boundaries. Now, American federalism has resulted in the creation of 50 state criminal codes, the creation of a separate U.S. criminal code, and numerous city and local ordinances detailing many types of violations. So it's not just one, everybody has the same laws all the way across every state in the United States. Because of federalism and the fact that states can make or regulate some of their own laws, we have a lot of different codes and a lot of different laws. And part of the importance of this entire thing would be something called separation of powers. And the U.S. government and the governments of all the states are divided into 3 branches, which are the legislative, executive, and judicial branches. And I know this is History 101, but it's important to understand, especially as it relates to criminal law, would it be really good if some one entity was judge, jury, and executioner, if you will? That's probably not, it may have worked a long, long time ago, but it's not going to work now, because you don't want one individual or one particular group to have all of that power. Therefore, we have the separation of powers. And legislative, Article 1 of the Constitution establishes basically a 2-chambered Congress. We have the House of Representatives and the Senate. Congress declares what acts are criminal, defines the criminal process and the respective authorities of the government players, and establishes the punishments for each crime. And each state has its own legislature that makes its own set of criminal laws. And then you have the executive branch, and this is the role, where the role of the president is established in Article 2 of the Constitution. All executive authority is vested in the president and any lower offices that are created. The president is the chief law enforcement officer of the United States, and it is the responsibility of executive officials to investigate, prevent, and prosecute crime as well. And then finally, the judicial, Article 3 establishes the Supreme Court and such inferior courts that Congress chose to create. Now, in 2015, the federal judiciary included 1 Supreme Court, 13 appellate courts, and 94 district courts. In addition, there are several specialty federal courts like bankruptcy court and the court of claims and even military court. But what about, as we're staying with separation of powers? So here's just kind of a couple of photos when we talk about the Supreme Court and the justices. Now understand, if you don't know, the Supreme Court of the United States has 9 justices with 1 Chief Justice, and it's kind of a hierarchy. Here's a photo of the Supreme Court. Kind of continuing on here with judicial, each state has its own court system. Most states have 2 or more trial courts, 1 appellate court and 1 high court, and state courts continue to hear more than 90% of all criminal cases. And courts hear and resolve legal disputes, oversee specific dimensions of the criminal investigative process, oversee the prosecution of cases once charges are filed, and act as guardians of the governmental architecture. And judicial review is the authority of a court to review the actions of the executive and legislative branches and to declare as void those not consistent with the Constitution. And just a really quick look at the court system, if you will. And it's, again, it's just very quick. So the highest court in the land is going to be the United States Supreme Court. And on the left here, we have the federal side. And again, there's a couple of other courts here, but you have the U.S. District Court, which are the trial courts, and then you have the U.S. Court of Appeal. Okay, there's 94 federal trial courts, 13 circuit courts or appeal courts. And on the state side, every state has a Supreme Court. Okay, it's not the same as the United States Supreme Court. That's the highest court in the land. But every state will have a Supreme Court. They have an intermediate appellate court. And then the one that you're probably most familiar with would be the state trial courts across 50 different states. So trial court, appellate court, state Supreme Court, U.S. Supreme Court. District courts, Court of Appeal, Supreme Court of the United States. So just a very, very quick overview. In Canvas, I also have some videos on the different court systems. While they are not really super duper exciting, they're very informative and they're short, and it wouldn't be a bad idea to watch them. So moving on, we understand that the process, or the due process system, if you will, is adversarial. So like other common law nations, the United States employs an adversarial and accusatorial system. An adversarial accusatorial system is like a contest in which the prosecutor is pitted against the defense. In contrast to something like an inquisitorial system, which is more like an ongoing inquiry with both the prosecution and the defense seeking the truth. Now, so in this type of system, again, the prosecution and the defense are basically against each other, and the system is punctuated by the processes. So, you know, the accusatorial process assumes that truth is best found by having competing forces, searching, analyzing, and then ultimately representing their facts and theories. And here the judge plays a more passive role in the adversarial system than in the inquisitorial system, largely acting basically as an umpire between the parties and generally overseeing the system, if you will. So as I kind of said, this process assumes that the truth is best found, and I kind of agree here that, you know, between the two forces, basically analyzing, searching, and ultimately presenting their facts and theories about what took place. And the government bears the burden of proof in this adversarial or accusatorial due process system. The defense has no obligation to prove that the person is innocent. The government, again, bears the burden of proof here, and the burden of proof requirement requires the prosecutors to prove guilt under what we call beyond reasonable doubt, which basically means having no doubt. And why do you think it's that high? Well, the reason it is because we don't want to make that burden lower, because you're talking about somebody's freedom. So we've placed the bar very high to where it's beyond a reasonable doubt, and where, again, the government bears the burden to prove this. It's not the other way around. You're innocent until proven guilty, not guilty until proven innocent. So a couple of different levels, because I kind of walked into the part about, let me go back here real quick, this beyond a reasonable doubt. So let's look at a couple of different levels, if you will. Preponderance of the evidence, a couple of definitions. This level is for determining the legal liability. A probability of just over 50% that the defendant did what they said. Another level is clear and convincing evidence. This level of factual proof is used in civil cases involving the issues of personal liberty. So it requires greater certainty but more probable than not. But it's not as demanding as reasonable, no reasonable doubt. And here's a good example of the process system. And again, it could be different in different states, but if you can kind of look at the bottom here, both of these deal a lot with search and seizure, but then you can start to see preponderance right here, clear and convincing evidence, and beyond a reasonable doubt. And here's the corresponding definition. So these are levels of proof. And depending upon what type of case it is, criminal, civil, etc., there might be a different level of proof. So now we're going to talk about something called the rule of law. And the rule of law is sometimes referred to as the supremacy clause. And this involves the belief that an orderly society must be governed by established principles and known codes that are applied uniformly and fairly to all of its members. And it includes the notion that due process of law is necessary before the imposition of any punishment on lawbreakers. So we're not just saying, hey, you're under arrest and here's your punishment. There needs to be that due process of law. And part of that due process guarantees individual rights are protected. And this basically states that the Bill of Rights that I told you that you should understand, originally intended to restrict federal government, must also apply to the states through the 14th Amendment's Due Process Clause. And only the rights found by the Supreme Court be fundamental and necessary to an ordered liberty are incorporated. So I know that was really kind of quick, but I would again ask you to read the summary information at the end of the chapter, and also look at the key terms. They're listed in the book, but I also have them built into your Canvas shell. So with that being said, I did make it under 60 minutes. That is the end of the Chapter 1 lecture. Until next time.